Now I guess I am audible. Yogesh, please confirm if audio and video is clear. Okay, thank you. So, welcome you all to this seventh lecture of N100 series, in which we are discussing the polity concepts from mains perspective. That is, we are taking up themes on which a question can be asked in civil services mains exam. And since we are discussing it from mains perspective, we would be going in detail of all the themes, and also we shall be looking from multiple perspective on which a question can be asked. We shall also be giving you the value addition content, examples, data, the constitution articles, the Supreme Court judgment that can be quoted in an answer. And time and again, we shall also be discussing a few UPSC questions that have been asked in the past. Okay, so my name is Madhusudan. I will be taking you through polity, and similarly after completion of polity the other subjects shall also be taken. So stay tuned with us. Do tell your friends also about this initiative of ours. Okay. Today my health is slightly on the downside. Please bear with me. So today's class, I am going to take you through federal structure, and this is a very important topic in this year's civil services mains. Also, a question was asked on center-state relation. In fact, it was a direct question that in recent times, what are the changes that have been introduced by union government? And we shall see that naturally, we all have been preparing for it, directly or indirectly. But UPSC is just asking you to compile all the things that we have studied in last 1 or 2 years in current affair in a static part, to put them in one place. Okay. In third lecture, like in today's class, we shall focus on administrative relation and legislative relation between union and state. In tomorrow's class, we shall focus on financial relation, and some other aspect, asymmetric federalism aspect will also be dealt. And the day after tomorrow's class, I shall also be discussing you the recent trend, the recent changes that are happening. So in these classes, we cover both static as well as the current affair aspect of the topic. Okay. And in this, the syllabus of our UPSC mentions something like this: functions and responsibilities of the union and the states, issues and challenges pertaining to the federal structure. The more important aspect is this only. All the questions that have been asked in the past are like issues and challenges pertaining to federal structure. So first thing first, we need to know what federal structure means. Can you tell me, what do you understand by federalism? Or a question which is often asked is that, what are the features of federalism? This is something that has been asked in the prelims also. What are the features of a federal state? Please tell me at least one or two features I must get from the students also. Anything that comes to your mind, you must write. See, this class has to be an interactive class. Different government at different level, or rather what Yogesh is saying, that there has to be at least two level of government. One at the center level or at the national level, another at the constituent level, which is also called a state level or provincial level. Okay, so see, this is a country. The one way of governing the country is that there is one government, which we call as central government or union government or federal government, whatever name it is called, is governing the whole country. There is only one government. But see, there are issues, or like as the size of a country increases, it often becomes very difficult for one government to look at all the issues, because various issues are local in nature. There would be diversity in the country. The issues of this part may be different from the issues of this part. Some issues may be, some region may be having flood, some region may be having drought. Okay, so that's why it is often said that as the size increases, probably for one government to look after all the issues is not possible. So the country is further divided into a small part, which is often called as provinces. and we have one government at the center level, which is called central government or federal government or union government, and another government is at provincial level. And when we have this kind of arrangement, we call it as federal system. So these are the features of federal government, and what we were just talking about is dual government polity, that there is government at or there is two government at two different level. Okay. Second is, obviously if there is going to be two different government, then there has to be a division of power. Which work would be performed by provincial government and which work would be performed by the central government has to be decided. So this is called division of powers. There is a different term called separation of power. Students often get confused between the two. Separation of power is between three organs of a state. That is between executive, legislature and judiciary. So they have separation of power. When the term division of powers is used, it denotes the division of power between union government and a state government. Okay, and this division of power has to be written somewhere, because see, there are two government. Both government will ultimately say there would be time when they would like to increase their power. They would like to exercise. Sometimes there is a possibility that provincial government might like to enter into the domain of central government. Central government might like to enter into the domain of provincial government. So this has to be codified somewhere. So that's why there has to be a written constitution, and that constitution has to be supreme. Like, see, all the constitutions in the world, they are invariably subject to amendment. But unless and that amendment would be done by one of the government or the parliament, whatever you may say. When I am using the word government as such, I am not referring only to the executive part. I am here in this discussion. When I am referring to government, I am referring to all the three organs collectively. So obviously, some of the government will have the right to amend the constitution, but unless the constitution is supreme, this division of power or whatever be the provision in the constitution cannot be enforced. So that's why the constitution has to be a supreme document as well. And in case there is a dispute between union and a state, there are two government, there can be definitely a scope of dispute. For that, there has to be an independent judiciary to look after the disputes. This is a very important feature. Once UPSC has asked in the prelims exam also, it gave various options which of the following are the features of federalism, and most of the students made the error that they did not take independent judiciary. This is a key feature of any federal structure. If judiciary is not independent, suppose judiciary is subject to union government, union executive or parliament, then we cannot say that. I mean, the states cannot expect a fair trial, fair judgment. Okay. And then the union legislature has to be bicameral. Why bicameral means two houses. Why there has to be two houses? Because see, at the union government, I mean, whatever be the legislature, there would be one house which would be representing of the union or of the nation in totality, nation as a unit. But since there are various states which are constituting this nation, there has to be another house to protect the interest of the states. Okay, so one house will represent the interest of central government, and there would be another house which will represent the state of constituent unit. In India's case, it is a state government. Okay, is it clear? So you should not only remember that these are the six basic features of federalism, you should also remember the rationale behind these features. Merely writing these 6 points may not give you the exceptional mark. If you want to get the exceptional marks, apart from writing this point, you have to write a bit of explanation. And the best explanation is to explain why or how you give some logic, some analysis. So rather than, I mean, what is like an average level. When you explain why also, it puts your answer in an exceptional category where you can expect 60 to 70 to 75% of the marks. Okay. Now, the next question which is often asked is India a federal system? Why this question has been asked, I will first explain you. Till the time you can answer me in the comment section. What is India federal system? Why the doubt is being raised is because the Article 1 of our constitution says that India is a union of states, and constitution nowhere uses the word federalism or federal. Constitution doesn't use the word federal. Union word has been used. So the question that is often raised is whether there is a difference between the two and whether India is a federal system or not. What's your take? Is India a federal nation or does India have a federal system? Yogesh is saying that India is a quasi-federal. Okay. Yogesh, you may also mention why we are saying it as a quasi-federal, but I will definitely deal with it in our today's class. See, in all the topics, some of the portion would be a static in nature that you would be knowing. I would expect you to give quick reply to me, and some of the top part would be based on the current affair, in which I shall be giving most of the replies to your questions. More power to central government. Very good. So the first part of your answer, whenever this doubt is raised, is India a federal system? Your answer should be yes, India is definitely a federal system. Why? Because you will simply say, look at these features of federalism. And all these 6 features are present in India. India has union government and state government. So there is dual government polity. And there is division of powers. Where is this division of power? In Schedule 7. There are 3 lists: union list, concurrent list, and a state list. After that, you will say that we have a written constitution which was enacted in 1950. After that, you can say that we also have an independent judiciary, and we have seen it in the last class that Supreme Court has declared independent judiciary as a part of basic structure of our constitution. So this is something which is inviolable. Independent judiciary is at the core of our constitution. Next, we have bicameral legislature. We have Lok Sabha, which is representing the union government, central government, and we have Rajya Sabha, which is representing the states. And obviously, there is supremacy of constitution. This is also, you can say that this has also been declared a part of basic structure. So since all the 6 core feature of our core feature of federalism is present in our system or our country, we can definitely call it a federal system. There is no doubt about it. But what Yogesh is saying, and see, you must write it in this way, you must give examples why we are writing or whatever we are saying. Okay. The next thing that you should keep it in mind is that why few people are calling it as quasi-federal, because there is deviation from the federal system of USA. USA's federal system, USA is considered as pioneer of federal system. United States of America Okay. See, in USA, what happened that states were pre-existing. If we have to simply tell you the difference between USA and India. So, in USA, states were pre-existing. They formed an agreement between them and they came together. All the states, they were pre-existing. They came, they formed, they made an agreement, and they formed out of the, as a result of this agreement, the nation United States of America was born. Since a state came together, they formed a federation. So that's why their government is called federal government. Okay, so states, I mean, it's simply, you can think of like there were say 50 of your friends. They all of you were having your own jurisdiction, your own independent thinking, etc. You come together and say that, see, I mean, in our interest, it would be good for outsiders if we talk as one unit. We would be relatively more safe, we would be more prosperous, there would be a lot of economic well-being, a lot of strength, there is a lot of benefit in coming together rather than living separately. So you said that, see, we will have our own power, we will make an agreement that we will have a federal government. We will have one government which will look after, which will have a jurisdiction running over all of us. And that government, we surrendered some of our powers to that government. Okay, and the states retained their respective power as well. So in this agreement, they decided that there is going to be a federal government which will have particular functions, and they kept some functions to the states and some other functions they devolved to the federal government. This is how USA was formed. But for India, the situation was opposite. For India, first India came into being. India became independent. And then all the princely states were asked to join India, the nation. Okay, so India came into being first and then states joined it. Or rather, what we did, we divided this country called India into several constituent units for administrative convenience. Okay, so here India came first, and then this India was further divided for divided into constituent unit for administrative convenience. As I told you earlier, that it is not possible to govern such a large country by one central government. So what we did, we divided it into various constituent units which are today known as states. Okay, so in India, since the nation came first, that's why states have relatively less power. Here, since a state came first, they formed an agreement. That's why here states are more powerful. Here, the union government or nation is more powerful. Okay. Here, union was pre-existing, and that union was further subdivided into constituent part. Okay, and that's why there's a term used that India is a indestructible union. This is something that must be there in your answer. Indestructible union of destructible states. Our states are destructible. Earlier, Jammu and Kashmir was a state. Now it is an union territory. Okay. Earlier, like states of Telangana and Andhra Pradesh were one state. Then they become two different states. Similarly, so our states are destructible, but the union, the India is indestructible. You cannot destroy something called India. India is there to stay. Okay. Whereas in USA, both their federalism is also indestructible as well as their states are also indestructible. It is not possible in USA that the federal government will decide that tomorrow we will merge two states into one. Now we will have only 25 states, or subdivide certain states and make 100 states. That is not a possibility in USA, which is a possibility in India. And there are other centralizing tendency as well that I will make you write, because of which we are saying that India is a quasi-federal, or other what I am saying, that this USA is the kind of federalism that USA had, since it was the pioneer of the federal system. Any deviation from USA system is termed as quasi-federal, that you are not a pure federal kind of system. USA system is considered pure system, any deviation is considered as quasi-federal. But then you have to negate that argument and say that the core features of a federal system are possessed by India also. So India is a federal system, and federalism has also been declared as a part of basic structure in S.R. Bommai judgment. In S.R. Bommai case, Supreme Court has declared federalism as the part of basic structure of our constitution. So you have to take a firm stand. You have to first write why few people are saying it as a quasi-federal. Okay, argument is simple. USA, the kind of system USA was possessing, is being considered as pure federalism. Since India is deviating from that US's kind of system, that's why few people are terming it as quasi-federal. And what are the deviations? Depending upon whether the question is in 10 marks or 15 marks, you have to list down the variations. Variations are mostly in the nature of centralizing tendency, that Indian central government is more powerful. So some of centralizing tendency I have told you here. Some I will tell you when I am going to study the center-state relation. Okay, and in the end you will say that just because we are deviating from USA system, you cannot say that we are not federal. We are still federal because the core features are being possessed by us, and also the same has been declared by Supreme Court in S.R. Bommai case as well. Clear? Next part. Next, when you have to study the center-state relation, we are going to study the center-state relation in three domains. Okay, the first domain is going to be legislative domain, second is executive domain, and third is financial domain. Today's class I am going to cover you the legislative domain and executive domain. Third domain we are going to cover in tomorrow's class. Okay, so first thing first, let's talk about the legislative domain. So there is this thing called part 11 of our constitution. If you go and look at the constitution, it says that part 11 is relations between the union and the states. Relation between union and state. This is the name of the part itself. And in this, the very first chapter is, this you may not remember, but just to give you an idea, I mean it is more beneficial in prelims. You must have a clear-cut idea of the way our constitution is written. Okay, and first chapter is legislative relation. Okay, so you must remember these articles as well. Article number 245, it talks of the territorial jurisdiction. Keep this in mind, 245, 246, just one place, and there is 246 also. So this talks about territorial jurisdiction of laws made by parliament and a state legislature. This is common sense that suggests that the jurisdiction of laws made by parliament would be throughout the territory of India, and jurisdiction of law made by a state legislature would be limited to that particular state only. Now, okay, if I give you a statement that the laws made by parliament can have extraterritorial jurisdiction, or rather can have a jurisdiction outside India also, is it true or false? If I give you a statement that the laws made by parliament can have extraterritorial jurisdiction, that is jurisdiction outside India also, is it true or false? Yogesh is saying no, that's not true. Anyone else with any other opinion? The correct answer is it is true. Parliament can make an extraterritorial law. See, two things. First thing is the one that you are guessing. There are embassies which are outside India. To govern those, India can have an extraterritorial jurisdiction laws. And there are also things, at times it may be needed to make a law to govern Indian citizens outside India, or even like Indian national symbols, etc., like Indian flags. India can make a law to govern how Indian citizens or Indian flags are being treated outside the territory of India. Okay, or like Indian citizens, when they remain abroad, what they can do, what they cannot do. It There can be laws to govern them. How they will carry the passport, how will they will not carry, what they will say, not say. So that's why it is allowed that Indian Parliament can make extraterritorial laws. The same is not allowed to state legislatures. Okay. Next is Article 246. Just to memorize it, you can remember it. It has Schedule 7, and the article number has all the even numbers before 7. 2, 4, 6, 7. Okay. Just for the purpose of memorizing it. So this mentions the subject matters on which the two legislature, parliament and state legislative, can make laws. You must be knowing, I am just repeating it quickly. On the union list, union government, rather parliament can make law. On the state list, a state legislature can make law. On concurrent list, both a state legislature as well as union government can make laws. I am sure you must be knowing it. The three lists which are there in Schedule 7. If you have certain doubts, etc., you may ask it. The third is uh, this is a new article that has been introduced, Article 246A. This is for GST. Can you please tell me who can make laws to amend GST, or for the purpose of levying taxes in the form of GST? Whether it is union government or state government, who has got the jurisdiction? You guys is saying union government. The correct answer is both. There is CGST and SGST. So since SGST is a state GST, it goes to the state government. SGST, the laws related to SGST are made by a state legislature, whereas the laws related to CGST are made by parliament. Here there is a catch. Both of them will make laws as per the recommendation of GST Council. So theoretically, if the question is asked like who can make laws, both. But practically, both are limited by the recommendation of GST Council. So GST Council does not make a law. The power of taxation lies with the legislature only. So GST Council gives the recommendation, but these legislatures shall not deviate from the recommendation given by GST Council. This is how the system will work. No, residuary powers are there. There is no such list named as residuary list that is there in Article 248. It simply says that if there is any item which is not there in the state list, the parliament has power to make laws on it. So, which is not there in any of the list, on that item, the power to make laws lies with parliament. Okay, that is called residuary power. There is no such list named as residuary list. One more question that I would like to ask: for union territories, those union territory who do not have legislature, who has the power to make laws on their state list? There are items in the state, they would be relevant like land, law and order. They would be relevant for the union territories also. They also would require laws. Who will make law for them? It is parliament. So for UTs also the power to legislation lies with parliament. In fact, for the union territory of Delhi and Puducherry, those who have legislature, for them also parliament possesses the power of legislation. So parliament can legislate for these two territories also, but they have their own legislature as well. So it is the power of parliament which happen in case of UTs, it is the power of parliament which have been delegated to their respective legislatures. Okay. So this is the legislative relations between union and state. Next is executive relation between union and state. The list is slightly longer in case of executives. Executive relation starting from article number 256, 256, 57, 58, 61, 62, 63. These are the related articles. You must memorize these articles. This will also help you in eliminating options in prelims exam. So can you tell me what is this article 256? You have to think in terms of executive relation between union and state. So this article 256 says that, see, union parliament have made a certain laws, but on the ground the police or the administrative machinery is with the state government. So can a state government do something which will impede the functions of the law, or rather which will not allow the law made by parliament to be implemented effectively? Obviously, it is a possibility. Like some state governments are not happy with the Citizenship Amendment Act. So like union government has implemented a law, a state government are not happy with the law. So union government should have the authority, some power, privileges to implement the laws made by parliament. For that purpose, these articles have been made. Okay. So this article 256 directly says that the state government shall abide by the law made by parliament. So if parliament makes a law, the state government must abide by it. Simple. So a state does not have any choice. Parliament has made a law, you have to implement it. And also union's directive. Like union government has given some directive, you have to implement it. Now this is something you can start thinking of the centralizing tendency. A state has not been given any choice here, whether they like it or not. And the second is Article 257 make very specific that union can give directives to the state government. Union government can give directives to the state government. Can give directives means order can be given to the state government to do certain things. And these directives can include the directives for maintenance of means of communication. See, means of communication which are declared of national importance, they are under union list. railways, ports, they are in the union list. Okay. So, for their maintenance, directive can be given to the state government that you will protect, you will maintain certain national highway or certain railways line, railway station, etc. Okay. Including, like, these means of communication will also include railways. See, although even if simply it was written that union government can give directives to the state government, this would have been sufficient. However, our constitution make it explicit that it will include the directives to maintain means of communication. That would also have been sufficient, but explicit mention was given to railways also. Clear? I am just giving it you these things in detail so that the key terms remains in your mind. I am sure you must have read these articles, etc., but they are very confusing in nature and very difficult to memorize. Now, see, these are the things for which directive was being given to do something or something for that. Here, Article 258 simply says that union government can entrust certain functions to the state government. Rather, the wording is that President can entrust certain function to a state government. Obviously, it has to be a function which was in the domain of union government. Because if it is a function that is in the domain of a state government, there is no point of saying that it can be entrusted. So, president can entrust certain function to the state government, but logically, you should not entrust a function without prior consultation of the government. So, with the prior consultation of a state government. So, original constitution has only one way delegation of function, that is union government is delegating certain functions to the state government. Later on, through 7th Constitution Amendment Act, this article 258A was also added. A is mentioned means it's a Constitution Amendment Act, and this said that why would only president give some function to the state? Sometimes there is also a possibility that a state would like to entrust certain functions to the union government. So this is like a state government entrusting certain function to union government. And obviously, before giving any function to that person, in the spirit of cooperating federalism, the union government, the prior permission of union government must be taken. So that article says that the state government can entrust certain function to the union government with the prior consent. Okay. Now see, union government is giving some directive, making some laws. Say, suppose union government made a Right to Education Act. Now all the state government, it is binding on the state government to implement Right to Education Act, although the act was made by Union Parliament. This is a very correct example to understand this article 256. Union government made a directive that you have to maintain certain highway, you have to make it clear, do the protection, deploy certain police power and so on. Okay, or some functions which were there in the domain of union government, it gave to a state government. So since it was a function of the union government and some state have to do something, if any cost occurs, the state must pay, sorry, union must pay. So union will pay for any expenditure because of its directive. If there is any expenditure that occurs, that expenditure has to be paid by the union government. Logical? Then we have article 261, but there is no such provision like a state has given its function to union government. In this case, the constitution does not mention the state government will pay to union government. Why? Because union government has a lot of money. You must be knowing it. Okay. So, I mean, where are these poor states going to pay to the union government? It's in the nature of like union government is helping the state government. Okay. Now, let's move to article 261. This article has mentions full faith and credit clause. Full faith and credit to laws, documents, and court orders or judicial orders. So full faith and credit would be given to all the documents, laws, and judicial order across the territory of India. So if there is a law of say made by Telangana government, the full credit or full faith means it would be abide by the Andhra Pradesh government also. If there is a document issued by the one state, it has to be abide or respected by or accepted by the other. For example, suppose you are born in Andhra Pradesh, then you are migrating to Telangana. The Telangana government would not dispute your birth certificate, your marriage certificate, or your driving license. It would be as acceptable as in Telangana or rather in Andhra Pradesh. So whatever like your education document, we do graduation from any part of our any part in India, and that graduation certificate is equally valid across the territory of India. It's not that Jammu Kashmir government will say that no, I only accept the uh, graduation certificate issued by Jammu Kashmir government or any university in Jammu Kashmir. This will not happen. So throughout the territory of India, all the documents, even judicial order, suppose there is a marriage dispute between the two person and the court has ordered that the husband will pay X amount of alimony to his wife, but the husband and wife migrate to some other state. In that case also the same order which was issued in the earlier state would be applicable on them even if they migrate to some other state. Suppose someone commits a crime in say Delhi and then he goes to the uh, Bihar. Even in that case, whatever be the penalty which is applicable on that person as per the Delhi laws would be applicable. Even the Bihar government would abide by the orders of the Delhi court or the implement the laws made by Delhi government. This is the meaning of this article. A lot many students have very much difficulty in understanding. They remember that article 261 mentions about full faith and credit clause, but they do not understand. You must write a few of the examples that I have given to you to clearly communicate to the examiner that you understand this article very well. Okay. I am very happy with the students that few of you have liked it, liked the video without me requesting this time. Good, well done. Those of you who are watching it in recorded lecture must press the like button if you have not done so. Next is article 262. This talks about interstate river dispute. This says that the central government can form a tribunal for the dispute of resolution of any dispute of interstate river water, and that through an act of parliament, the jurisdiction of Supreme Court can be excluded. So no appeal lies from the judgment of Interstate River Water Tribunal to Supreme Court or High Court. Next is Article 263. This is about Interstate Council. Here also like this act, Article 263, this is only an enabling provision of the Constitution. This article does not create interstate council. It only allows president to create an interstate council through an executive order. So interstate council, if a question is asked in prelims, is a constitutional body, your answer is going to be no. It's a body made by executive resolution, so it's a non-statutory body. It's not even a statutory body. Leave about the constitutional status. Clear? Do you have any doubt with respect to center-state relation in the domain of executive relation? And see, in this sector, in executive domain, you can very clearly see that there is centralizing tendency. Right from the very first article, a state has to abide by the law made by parliament, has to implement it. Center can issue direction. There is, like, president can devolve with prior. At least in article 258 and 258A, there is an element of consent involved. But the first two articles, you can very clearly mention that these are the articles which are reflecting centralizing tendency in our federal system. Is it clear? But this centralizing tendency is not limited to the executive relation only. Even in legislative domain, we have centralizing tendency. So next we are going to study the centralizing tendency in terms of legislative domain. Okay, and in terms of legislative domain, this is the acronym through which you can memorize the centralizing tendency, or rather the first thing in legislative domain, what could be the centralization? So centralization could be in terms of when parliament can enter into the domain of state government. If parliament is allowed to make laws on a state list, this is a centralization. And these are the scenario, these are the 5 situations in which parliament can make laws on a state list. You can give a heading that under certain circumstances, parliament is empowered to make laws on a state list also. Union list it can make, on concurrent list it can make, but even on a state list it can make laws. And the acronym is simple, just to remember it. Rajya Sabha, for emergency, Rajya Sabha has done 2 SIP. SIP, I am sure all of you who are earning, you must be doing. If not, your parents must be doing. SIP is like when you are regularly every month investing in mutual fund. Let's say that you are doing an SIP. Okay, mutual fund sahi hai. These days we get a lot of ad also. So Rajya Sabha has also got 2 SIPs done for emergency. Let's understand its meaning. When Rajya Sabha passes a resolution under Article 249, then it empowers Parliament to make a law on a state list. Okay, this resolution has to be passed by a special majority, and this special majority is slightly different from the special majority we have studied for Article 368. This special majority is simply majority of 2/3 of members present and voting. So if two-third of the members present and voting, they pass a resolution. I mean, this resolution can only be passed in Rajya Sabha. In Parliament chapter, we shall also study it again. What is the special provisions or special power of Rajya Sabha? There also I will ask you. You must tell me. So if Rajya Sabha is passing a resolution with two-third majority that Parliament should enact a law on a state list, in that case Parliament can enact a law on a state list. Second is during national emergency. Article is 250. There is a dedicated article mentioning that in the time of emergency, Parliament can make laws on state list. So do not mention. This is also again relevant for prelims. Article number is 250, not 352. 352 is telling about other provisions of emergency, not this provision that Parliament can make a law on a state list. Okay, when I shall be teaching you from the prelims point of view, specifically maybe in the first half of the next year, at that point of time I will be asking you this question, and these small nitty-gritties you must keep in mind, because nowadays UPSC has become a little bit more difficult, tricky. It is going into small details. Okay, Next is 2S is when two or more states passes a resolution. This article is very easy to remember. There is 2 everywhere, 2, 5, 2, and it is talking of 2 states also. So when 2 or more states are passing a resolution that please make a law for us, they are requesting the parliament that please make a law. When can such a situation occur? It's like say there is a common capital for Punjab and Haryana, that is in Chandigarh. So to govern Chandigarh, neither Haryana alone can make a law, nor Punjab alone can make a law. So both of these states requested the parliament that please make a law to how to govern Chandigarh. Okay, so in such scenario, usually 2 or more states can pass a resolution. I is to implement international agreement. There is a very good example, like we have Lokpal and Lokayukta Act. So when this act was introduced or the bill was introduced in the parliament, a question was either okay, for central government you are making Lokpal, that's very good. You want to control the affairs related to this union government. But why are you making a Lokayukta Act? Lokayukta is something which is going to deal with the corruption of a state government. And how do you have the jurisdiction? You do not have jurisdiction. Then at that point of time, then Home Minister P. Chidambaram has argued that we have signed an international agreement to act against corruption. So to abide by the international agreement, to implement the international agreement under Article 253, the Parliament is making or instituting an office of Lokayukta in states. Okay, so this is how you, if you give one or two examples also along with these articles, your answer would be distinct from the answers given by the normal student. Next is P is during president rule. There are a lot many states under president rule is there. Yesterday only the president rule has been lifted from Jammu and Kashmir. Okay, and before you write the mains answer, definitely there will be one or two instances of president rule in one state or another. So this is another under Article 356. If a state is under president rule, the power to make laws is transferred to parliament. Now, if you could answer me that what is going to be the validity of these laws? Are these laws going to be valid forever? Or there is any time limit for which these laws are valid? Parliament has made a law for a state on a state list. So would these laws be valid forever or there is a validity period? Please answer. Yes, but can extend. Yes means what? Forever. See, these are the two, in the first two scenarios. As such, parliament is not empowered to make laws, but there is an exceptional circumstance because of which parliament has to make law or has to enter into the domain of a state government. So as soon as that exceptional circumstance is gone, normalcy, when normalcy returns, the law has to end. So the validity of the laws in these two periods is 6 months from the end of the exceptional circumstances. So here there is a resolution that has been passed and that resolution has empowered the uh, parliament to make a law. So in this case, the law will end 6 months after the resolution expires. In the second case, 6 months after emergency ceases to exist, the law will also cease to exist. So here, because there is a proclamation of emergency in place, that's why Parliament has got the power to legislate on state list. Here, because Rajya Sabha has passed a resolution. So here, because of the resolution, Parliament has got the power. Here, because of the emergency proclamation, Parliament has got the power. So as soon as this resolution ceases to exist, or as soon as this emergency ceases to exist, there is a 6 month window. After that, the law will also cease to exist. Whereas in these three scenarios, Parliament is simply acting as a state legislature. Okay, so any law made under these three scenarios, because here there is no state legislature, so that's why Parliament is substituting it. So whatever a state legislature could have done, same is being done by Parliament. A state Parliament is acting in place of a state legislature. Okay, here also the two states have simply surrendered their right to make law. They have given their right to Parliament. So Parliament is acting on behalf of the state legislature on their request. Here also there is an international agreement because of which all the state legislature are supposed to make a law. So rather than all the states making a law, the Parliament is making a one law for all the states. So in these places, since Parliament is substituting the state legislature, so that's why these laws are valid forever. Okay. Next question is, in fact, in this case, the two state article 252. This is a very peculiar thing. Two or more states have passed a resolution. They have surrendered their right to Parliament. Now, any further amendment or repealing of that act can only be done by Parliament. Once you have surrendered your right, that right is never gonna be back with you. So if it has to be amended in the future, a state legislature cannot amend. It has to request the central government only. Only Parliament can amend it in the future. Clear? Now let's move to the some other centralizing tendency. For example, Article 254. Like, there is a law made by Parliament and there is a law made by state. Suppose both of them had the jurisdiction to make law. Most common example is concurrent list. So in case there is any inconsistency between the laws made by Parliament and a state legislature, the law made by Parliament shall exist and the law made by a state legislature would be void to the extent of inconsistency. Now, what is the meaning of to the extent of inconsistency? It simply means that it may not be possible that the complete law is unconstitutional or in conflict. So, if some part of the law is in conflict, only that part of the law, suppose this is the jurisdiction of a state law, this is the jurisdiction of parliament law. So, this is the part where state law and parliament law are in conflict. So, this part of the state law would be void. Parliament law would remain here, the state law would be unconstitutional. Next is Article 3 and 4. Parliament can reorganize the states. This is something which is there in Article 3. Article 3 says that Parliament can reorganize the states, change its name, change its boundary, merge two states, and so on. All the possibilities are there, all the powers are there with Parliament. You can give the example of Jammu and Kashmir reorganization, or you can give the bifurcation of Andhra Pradesh into Andhra Pradesh and Telangana. Any example, there are so many examples are there. Article 4 says that, in the last class some of you had this doubt, that if any such amendment has been done, it would not require a constitution amendment. So this is done by a simple majority. See the kind of power that the kind of centralization that is there with union government. Only simple majority is required to alter the boundaries of the state, to merge to a state or demerge or split a state into two or three parts. Okay, so to destroy the state, only simple majority is required in parliament, and that is there in Article 4. Article 200 says that governor can reserve bills for consideration of president. Now again, president giving assent or president is applying, president can also use its veto power on a state bill. This is again a centralizing tendency, and the very fact that we have a governor appointed by central government is also a centralizing tendency. The governor is the head of the state government, and that head is appointed by the central government. In USA, governor is directly elected. Like the election of president, there is also the election of governor of the state. Okay. Then we have Article 248, we have already studied. Residuary power is there with parliament. In USA, residuary power is with states. In USA, this power is with states. So if there is a new item on which there is no clarity as to which where the federal government can make law or state government, in that case the states over there can make law. In case of India, this power is with the union government. Okay. Apart from this, you can also write some of the other aspect where we have centralizing tendency. For example, all India services. Like all of you are fighting for to get into one of the all India services, like our desired service for most of us is IAS or IPS. How many all India services are there? Can you tell me? How many all India services do we have? Two. No. We have three all India services. One is IS, IPS and IFOS. Indian Forest Service is the third All India services. There is recommendation to create many more, like Indian Judicial Service is requested, uh, Health Service and Education Service, there is recommendation for that also. But as of now, we have only three All India services. And the peculiarity of All India services is that they are appointed, recruited by the central government, whereas they work with the state government. If you are if you get IAS as a service after civil service exam, you will be allotted a state cadre. Andhra Pradesh, Telangana, Bihar, Jharkhand or any other state cadre. So if you are allotted a state cadre, you will work with that state government. You cannot work outside until unless you go for deputation. Whereas the recruitment exam is being conducted by UPSC, DOPT is going to issue you the appointment letter. So you are being recruited or appointed and even trained by the central government, whereas you work with the state government. So this is also a centralizing tendency, because suppose as a state government, I have, I should, I mean, I am the government, a state government, then I should have the right to appoint my personnel, my officers. But the central government is recruiting officer and giving it to me. Central government is training the officer and then giving it to me. This is also a anti-federal feature. Here also states are being weakened. Okay, like revenue services officers. They work for the central government. They are appointed by the central government, recruited by the central government, trained by the central government. A state government have their own revenue officers. They are appointed by their state specific civil services exam. Similar mechanism is not for IAS and IPS officers. That's why it is said that they are not in the spirit of federalism. Why they are is the separate matter that we shall study later on. Okay, there is one more thing, like we have a mechanism of single citizenship. In India, we all are the citizen of India. No one is citizen of say Maharashtra or Tamil Nadu or Delhi. This is in contrast to USA, where there is dual citizenship. A person is citizen of United States of America, at the same time he is also citizen of Chicago or citizen of New York, New Jersey, etc. So their respective state, they are citizen of respective states as well as the citizen of United States of America. Okay, so this is also, people are saying that the very recognition of a state is missing from the individual's identity card. The individuals are not being considered a member of their state or the citizen of their state. This is just an argument. It is like it is in our interest that we have made so, because we did not want a separatist tendency to propagate in our country. So we have the defense of all these things. Why we have all India services or single citizenship, or rather why we have centralizing tendencies, because there was a risk of balkanization at the time of independence. There was a need to have see, for all them together you can have the same argument, that there was a need to have a strong center to maintain the unity and integrity of the nation. You can write it down. Why we went for the strong center? Because there was a need to stop the balkanization of the country. To maintain the unity and integrity of the nation, we went for a strong center. Then we have a state emergency as another feature which is very much centralizing in nature. Till now, if you have any doubt, whatever things that we have covered, please let me know. Very good that you do not have any doubt. Now we shall see a state emergency. What are the features which are there with respect to a state emergency? A state emergency is also called as president rule. Can you tell me the article number? I have just told you as well, president's rule. As such, the word president rule is not mentioned in our, neither the word president rule is mentioned in constitution, nor the word a state emergency is used in the constitution. Yes, it is article 356 which mentions about a state emergency. What does this article say? This article says that in case there is a failure of constitutional machinery in states, this is the wording that is used in our constitution. In that case, all or any of the functions of the state government can be taken away by president. And that's why the name president rule has come. Why the word state emergency has come? Because in case of failure of constitutional machinery in a state, so that's why we are calling it failure, there is emergency in a state. Why the word president rule is there? Because in case of failure of constitutional machinery, all or any of the functions of the state government can be taken by president. President means union government. So that's why we are calling it as president rule. Okay. Then The president is part of executive, so president will take up the role of the executive functions. What about the legislative function and judicial function? So in case of legislative function, the power of legislation is transferred to parliament. But then it is going to be difficult for parliament to make all the laws for various state government. So a provision has been made in our constitution that such a power can be delegated to president, and president can further delegate it to an appropriate authority. Okay, there is one more question that I would like to ask. You must have seen this phrase, president by a warrant issued by president under his hand and seal. This term is often used, like appointment of CAG would be done by president by issuing a warrant under his hand and seal. What does this mean by warrant under his hand and seal? It simply means that president has to put his own signature and the seal of his office. President cannot delegate this function further to some other authority. It has to be done by president only. No delegation is allowed. Whereas here clearly it is said that president can delegate it further to any other person, that say suppose union law ministry or any other ministry can be entrusted with the task, home ministry, of making legislation for that particular state. Can you tell me the validity of such a law made? I have just told you. What would be the validity of such a law? The validity of such a law is forever. Yes, you are right. Such a law would be valid forever. Okay. And then, like in emergency, we have seen that there was the provision of periodic approval. So is the provision here that there is requirement of periodic approval every 6 months. What is the majority required here? But so unlike the national emergency, here the majority required is simple majority. We do not require a special majority. And the next thing which is required here is under no circumstances a state emergency can remain in force for more than 6 months. So maximum period is also prescribed, that is of 3 years. Sorry. So unlike national emergency which can remain in force for as long as it is getting periodic approval, the state emergency cannot remain in force beyond 3 years. Okay. In fact, if it has to remain in force for a period more than 1 year, there has to be either of the two scenarios, then only it can remain in force for more than 1 year. So if it has to be in force beyond 1 year, then either of the two circumstances must necessitate. The first circumstance is that election commission should certify. Election commission is interested with conducting elections. So if election commission issues a certificate that it is not possible to conduct election, in that case in that case the election would not be conducted. I mean, if election cannot be conducted, it means it will remain in force beyond 1 year. Or if national emergency is enforced. So in case there is national emergency enforced in that state, in that case the president rule can extend beyond 1 year time period. See, there is two different things here. One is, this is the this is talking about the existence of president rule itself, that for how long president rule would be there. And this provision, this forever, what I have, this validity that I have been talking about, is about a law made during president rule. So suppose like president rule was enforced today. What is the date today? 14th of October 2024. Suppose in any state ABC, today president rule is imposed. Tomorrow on 15th of October 2024, and law was made by parliament. Okay, any law can be made. Now, this law would remain valid forever. Whatever law is made tomorrow, this will remain valid forever till the time the state legislature repeals it or make any amendment to it. Whereas the president rule which was imposed here will lapse after 6 months if it is not approved by both houses. Like on 14th October 2025, 1 year would be completed. So beyond 1 year, merely by approval of parliament, it cannot continue. It has to get either of these two things. One, if it gets the certificate from election commission that yes, it is not possible to conduct election, or suppose there is a national emergency which is proclaimed in that state. Okay, then only this will continue beyond 14th October 2025, and under no circumstances it can continue beyond 14th October 2027. The constitution clearly says that beyond 14th October 2027, you cannot continue president rule in a state. Now, a question must come to your mind, that in Jammu and Kashmir, president rule was imposed in 2019. Whereas the election is conducted in 2024. It's more than 5 years. So if it is saying that under no circumstances president rule can continue beyond 3 years, how was it enforced for more than 3 years in Jammu and Kashmir? Do you know it? The answer is simple. Jammu and Kashmir is not a state. Jammu and Kashmir is union territory, and this protection has been given to a state government. Probably central government had this wisdom in their mind that it may not be possible to conduct election within 3 years. That might also be another reason why a statehood was taken away from Jammu and Kashmir. Once, yes, Yogesh, you are right. Jammu and Kashmir is a union territory. That's why they do not have this protection. Next question is, like we have discussed about who will do the executive function, like president would do. Who will do the legislative function? Is there any change in judicial function? If a state emergency is imposed or president rule is proclaimed for a particular state, is there any change in the judicial function of the state? The answer is no. There is no change in the power of High Court to function in that particular state because of the proclamation of a state emergency. Is there any change in the fundamental right of the citizens? Again, the answer is no. Fundamental rights are directly coming from the constitution, and it has only national emergency has some bearing on fundamental rights of the citizens, not a state emergency or not even financial emergency. Clear? See, the kind of question may not be directly that what are the provisions for a state emergency. There could be a question like to avoid the misuse of the emergency provision. What are the provisions in our constitution? This could be the questions that this, or there could be a question like despite having various safeguards against the misuse of a state emergency, it is very often misused. Okay, so since it is saying that despite having provisions, you have to mention what are the provisions. You have to mention these provisions, that there is a requirement of periodic approval in both houses of parliament every 6 months. There is a maximum period of 3 years. Beyond 1 year, it can continue only if either of the two condition is satisfied, and all these things are there. Okay, then you have to mention that still there is very frequent misuse. In fact, Dr. B.R. Ambedkar has said that this is going to be a dead letter in our constitution. Unfortunately, this dead letter has been invoked more than 300 times. Okay, in fact, this dead letter was first used in 1951 itself in case of Punjab, when a duly elected Punjab government, which was in majority, was removed from the office. Okay, so the first instance of use of president rule was there in 1951 itself. In fact, it was very much misused, very widely misused, because see, when Indira Gandhi has won the election with a thumping majority in 1971, it dismissed some of the other state government, which was non-Congress government, on the ground that they have lost their, like people have lost faith in them. Next time, when it so happened that when after 1977, the Janata Party government came, it also removed some of the state government on the ground that those governments have lost, like Congress have got lost, like people have lost faith in the Congress government. And the same thing have continued time and again. You must recall, or you must note down a few examples. Okay, and ultimately the matter went to the Supreme Court, and Supreme Court gave this landmark judgment, which is known as SR Bombay case. If any question comes on president rule, your answer must mention this judgment, because this is something, this judgment came in 1994, which changed the way Article 356 have been used. What was there? See, this was the case when the S.R. Bommai was the chief minister of Karnataka, and his government was dismissed because there were riots, and it was accused that the government was failing to, or the government was not taking action against the rioters. Okay, so S.R. Bommai went to the Supreme Court and said that I have majority in legislature and still my government have been toppled or removed using this article. So this is unconstitutional. Supreme Court says that yes. Supreme Court gave certain landmark things, some points that you must keep in mind. First, Supreme Court said that even the first thing that he has to rule was that whether when president decides, like in the opinion of the president, the constitutional machinery has failed in the state, or the government cannot be run in accordance with the constitution, can Supreme Court review it? The Supreme Court said that yes, the imposition of president rule is subject to judicial review. The first and foremost thing, or the most important thing that was told in this judgment, was that it is subject to judicial review. Second thing said, the Supreme Court also said that it mentioned certain specific grounds for dismissal of the government. It said that, and it also mentioned certain things which are not a valid ground. Like certain circumstances are a valid ground, certain circumstances are not a valid ground, which was mentioned by this S.R. Bommai judgment. What were they? That say that when there is a breakdown of constitutional machinery, you can go for dismissing the state government, but not for administrative machinery, or when there is accusation of corruption. Constitutional machinery means, see, the constitution says that there has the council of minister has to be uh, answerable to the house of people or a state legislative assembly. So when council of minister has lost confidence in the house of state legislative assembly, in that case there is a breakdown of constitutional machinery. So whatever arrangement that constitution has made, if that arrangement is not possible, that is breakdown of constitutional machinery. Okay. Then like article 365, it clearly says that when a state government does not abide by the instructions given by the central government, it would be considered that there is a failure of constitutional machinery in the state. Okay, so obviously the Supreme Court also has to tell that if Article 365 is saying that union directive has to be abided, has to be implemented. Okay, then the Supreme Court also said that the floor test means whether a particular government has lost majority or not. How are you going to ascertain? So the only mechanism to ascertain the majority of the government is on the floor of the house. You may write it down that the only mechanism to ascertain the majority of a government is the floor of the house. That is, on the state legislative assembly there has to be a voting. Through voting only you can know whether a particular government has lost majority or not. So that's why you can say that in Maharashtra the governor asked the Uddhav Balasaheb Thackeray to prove majority in the state legislative assembly. Okay, I will repeat this point. The Supreme Court says earlier what was happening, that when like governor were sending the report to the central government that this particular chief minister has lost the confidence of the house, and then president rule was being imposed. So I mean the governor's report or a governor's meeting with the various leaders of the parliament state is not a conclusive medium for deciding whether a particular government has lost majority or not. The Supreme Court clearly said that whether a government or a chief minister enjoys majority or not would be decided through a floor test. That's why I'm saying there is supremacy of floor test. So on the floor of the house, like in the state legislative assembly, through voting it would be decided whether a particular government has lost majority or not. Okay, and in the example you can write that in Maharashtra when there was a split in the party, the governor did not impose president rule, rather asked the chief minister to prove his majority through a floor test. Clear? Next is, it said that federalism and secularism. Federalism and secularism are part of basic structure of our constitution. What impact did it have? See, now what Supreme Court said, that since the SR Bommai government or the Karnataka government has not been able to stop the communal riots or have not been able to act against the rioters, it has not been able to protect secularism. And since secularism is part of basic structure of our constitution, if you have not been able to protect secularism, it means there is a breakdown of constitutional machinery. So Supreme Court gave all this argument that yes, you are right, there is judicial review possible, the government cannot, if there is a mala intention, in fact court also said that if we find that there is a mala intention behind imposition of Supreme Court, the government can be restored. The government which was dismissed by the president rule, that state government can be restored. In fact, the legislative assembly can also be revived. The Supreme Court has got the power to revive the Legislative Assembly. It gave all this good argument. The Supreme Court gave all this argument, and then to S.R. Bommai, the Supreme Court said that in your state, communal riots have happened. You have failed in protecting the secularism, and since secularism is a part of basic structure, there is a breakdown of constitutional machinery. So no respite was given to Mr. S.R. Bommai. So he became history because of this judgment. In his name is immortal in the books of the polity. We study all them, but his government was not restored. The president rule was considered valid and constitutional in Karnataka at that point of time. Okay. Next is that secularism is a ground for imposing president rule. That's what I was telling you. But this judgment have had a very far-reaching impact. What was the impact? This is a question that can be asked again, that what was the impact of S.R. Bommai's judgment? And the impact has been far-reaching. The first and foremost impact is that the misuse of president rule has definitely reduced. See, between 1950 and 1994, in which year this president rule was imposed. The president rule was imposed around 100 times. So roughly you can see that around 2.5 times a year. Whereas between 1995 to 2021, between 1995 to 2021, I am taking 1994 because this is the year in which S.R. Bommai judgment was delivered. Between 1995 to 2001, this was imposed around 29 times. So roughly you can say that in this 17 years, there is 1.5, roughly 1.5 times a year. So you can clearly see that the frequency of imposition of president rule has come down. See, one way of writing an answer is that you can write that yes, the frequency has come down, and then you can give this data to back your argument. You will definitely get more marks. Okay. Now there is accountability on part of the central government, because it has to answer in the court, it has to justify the ground on which it has imposed the president rule. Second is reduced misuse. You can give this article. And then various governments have been restored in different parts. Okay. Here you can write the example of Uttarakhand government. In Uttarakhand, president rule was imposed, and here the High Court itself found that it was unconstitutional. There was malified intent, and because of that, the Uttarakhand government was restored. So this is another good example of impact of S.R. Bommai judgment, because it acted as a precedent for future cases. In future also, like you can give the example of Bhuta Singh case. Here, the imposition of president rule was considered unconstitutional in Bihar in 2005. In 2005, when president rule was imposed in Bihar, the ground used was, there was horse trading. The Supreme Court says that horse trading cannot be a ground for imposing a president rule in a state. And also Supreme Court has stated that you cannot can't dissolve the a state legislative assembly without parliament approval. So in case you do not take the approval of parliament, you cannot dissolve the state legislative assembly. Okay, so state government can be dismissed. So there are two things. One is dismissing the executive government. That is simply done by president proclamation, president order. But the dissolution of a state legislative assembly should be done only if parliament has approved that president order. Okay. And then you can say that there has been more stable government in the states, because earlier on the grounds of one more thing was said, that in case of a poor performance of a political party in central election, like in the national election, cannot be a ground for uh, applying president rule. You cannot say that see particular political party has performed poorly in Lok Sabha election. For example, in Delhi, it is always there. Like Delhi government, the AAP government, which is in Delhi, performs extraordinarily well in Delhi election, whereas it performs very poorly in national election. So this cannot be a ground for imposition of president rule in Delhi. The Delhi government can be removed only if it performs poorly in a state election. Okay. So there is a stable government now, and it is also leading to better governance. So definitely SR Boy judgment, this is not a judgment which is being considered controversial, unlike the basic structure doctrine judgment, Kesavananda Bharati judgment. This is a judgment which is very well respected. It has only positive connotation. Do not give any negative argument for sake of giving an argument. Okay. So that's all that we are going to cover in today's class. In the tomorrow's class, we are going to cover the uh, financial relation between center and state. We are also going to cover some of the doctrines which are used by Supreme Court for interpreting the constitutionality of various laws made by center and state. Okay. Apart from that, some of the issues like tussle between Delhi government and central government, we are also going to discuss in the next class. Okay. So see you again tomorrow, 2 p.m. in the afternoon. From tomorrow onward, we shall try that technical issues are sorted out, and we will have a full 2-hour class. Do tell your friends also to tune in at 2 p.m. The day after tomorrow's class, I am going to discuss you also the question that was asked in 2024, like various current affair related questions. Okay, so see you again tomorrow. Take care. Have a nice day.